Good evening, ladies and gentlemen. It's 6 o'clock. Time for us to begin our regular meeting, the second of our regular meetings for the month of, what is this month? May already? It'll be June in a few days. We'll ask Jamie Jordan to come, lead us in the invocation, and we'll simply present him tonight as a man of many hats. Appreciate you. Thank you. Appreciate you, Jamie.
Appreciate you, sir. Let us pray. Lord, we give you thanks for this day. We thank you for all the good things that have taken place, and forgive us for taking those things for granted, as we may so often do in the busyness of life. Lord, we acknowledge that you're in authority over all things, including the proceedings before us. So, Lord, may your wisdom be known. May your love be shared. May your grace just be poured out upon each and every one that is here, Lord. I pray you bless these leaders before us, and I thank you for their sacrificial love and leadership for this city of Richmond. And I pray that you'll give them your wisdom to discern what is good, what is right, what is beautiful for the people of Richmond, Kentucky, Lord. Be with those that are in attendance here, those who are watching online, Lord. I pray your blessings upon all, that we may be a blessing to one another. In this, I pray, in the name of the Father, and the Son, and the Holy Spirit. Amen.
Amen. Thank you, Jamie. Lots of folks, whether they have housing needs or other needs, are blessed by the work of Jamie Jordan, and we're greatly appreciative of all that you do, Jamie. Serves on our housing boards, that being the Public Housing Authority and the Section 8 Housing Authority. Thank you. We're honored to have a local U.S. Armed Forces veteran with us to lead the Pledge of Allegiance. We're pleased to welcome Alvina Maynard this evening. Mrs. Maynard is the owner and operator of the River Hill Ranch, where she has been raising alpacas since 2012. She has made her home in Richmond for 14 years. Lieutenant Colonel Maynard is an Air Force reservist, serving as an investigator from 2005 to present, 11 years being active duty service. Thank you, Alvina, for leading our Pledge of Allegiance for us this evening.
Thank you, Mayor. Thank you for having me. Would you all please rise? Place your right hand over your heart. Ready, begin. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated.
Thank you. How are the alpacas doing?
Mayor, they're freshly naked. So they're good. They're good. Yeah.
That's
He
a
doesn't
good
even know what to
thing.
say
They're
to that.
relieved of their sweaters, so they're good. Yeah.
Yes,
On to
indeed.
make their sweaters into socks and other sweaters.
Fascinated with
Thank
what
you
you're
for
doing
asking.
in this area. Thank you, and for
Thank
being
you,
willing to come to be with us tonight. Madam Clerk, please call the roll.
Commissioner Goebel.
Here.
Commissioner Newby.
Here.
Commissioner Brewer.
Present.
Commissioner Cole.
Here.
Mayor Blythe.
Here, thank you. And happy to hear this one here answer the roll call.
Glad to
Certainly
be
with
here.
his surgery.
Yep.
Let's see, Madam Clerk, we have a presentation of a new business tonight.
Yep.
Carrie Hensley, if you'll come forward, please.
Good evening, Mayor and
Good evening.
Commissioners. We have a new business to celebrate this evening. I'm going to ask Phil, Elizabeth, and Ella Cream to come up and talk about their new business called Poppy's Ice Cream. I've heard it's been real popular.
Yeah.
Hello,
Good evening.
my name's Elizabeth, and my husband and I, we've opened an ice cream shop at 220 West Water Street. We offer scooped ice cream, sundaes, milkshakes, and we have some signature sweets such as Mimi's Hot Fudge Cake, the Eternal Kernel, and banana splits, nacho ice cream nachos, a skillet cookie, We started our business in 2021 with an ice cream truck that we still have, and we're really excited to be downtown.
Very cool.
You all have any questions?
And,
Brought you ice cream.
Me
Oh,
too.
you're reading my mind. After you listed all that, I'm sitting there thinking, surely you brought some samples.
Oh, we,
But your reputation, I don't mind saying this, we were having conversation here at the desk 20 minutes ago, and your reputation has preceded you. Outstanding from what we're hearing, yes, indeed, and experiencing, too. Yes, indeed. Carrie?
good luck to you guys. Yeah. I don't think you're gonna need it. It's been unbelievable, but, you know.
Oh, we doing a photo?
Yeah, I've seen folks sitting.
Made it.
Prop you up.
Okay.
Yes, I'm working at it.
First ordinance is 26-17, an ordinance of the City of Richmond, Kentucky, amending Development Chapter 157 of the Code of Ordinances pertaining to home occupation. This is a second reading. Mr. Attorney, please, and before you begin, this reminded me so much. I'll have to get it all out tonight, Chris. This reminded me so much of my red letter edition Bible.
That's hilarious.
I appreciate that, Mayor. Hopefully the spirit moved me in drafting.
Quickly.
So I will be summarizing this since we had the first reading at the last meeting. The proposed ordinance updates and establishes two categories of home-based businesses, Type 1 and Type 2, each with different standards intended to balance economic opportunity for residents with the preservation of neighborhood character. Type 1 home occupations are the most limited and lowest impact category. They are permitted in all residential zoning districts without requiring any permit, as long as the business meets several strict conditions. These operations must use no more than 400 square feet of the home and must generate no visible or detectable activity from outside the residence. Specifically, Type 1 businesses may not receive customers, employ anyone who does not live in the home, receive deliveries related to the business, or produce or store goods or products on site. This category is intended for office-type or remote service occupations that occur entirely within the home with no external effects, and these Type 1 types of business are not the category to which we are going to require permits. Type 2 home occupations, however, will. These include any home-based business that does not meet the Type 1 criteria. These operations require a home occupation permit prior to beginning business activity. Type 2 businesses may occupy up to 25% of the home's total floor area and must meet several performance standards designed to ensure compatibility with surrounding residences. These standards include requiring the business owner to live on the property, limiting non-resident employees to one person, and prohibiting changes to the exterior appearance of the home. Parking must be adequate to accommodate customers without impacting neighborhood streets, while commercial vehicles, trailers, outdoor storage, or on-site retail sales are not permitted. Additional rules prevent visible signage, advertising on vehicles parked at the property, or any noise, odors, traffic, or other disturbances detectable off-site. For businesses involving food preparation, baked goods, or catering, the applicant must show proof of compliance with all applicable Kentucky health, environmental, and agricultural regulations before a permit can be issued.
Thank you, sir. This is ordinance 26-17. May we have a motion, please? This is a second reading. May we have a motion, please, to bring to the floor for discussion and approval?
So move.
Commissioner Brewer,
Second?
Commissioner Goble. Is there any discussion?
Mayor, if,
Yes, sir, please.
when we talk about these home employment or businesses,
Yes, sir.
anything that is prior to this is grandfathered in? Did we discuss that when I was absent?
How this would work going forward would be that, the businesses as they're currently licensed are free to continue with that. However, when it comes time for renewal, it could be a situation where you could have somebody that has been getting licenses up to this point, maybe in category type 1, to where we're no longer going to require them to be permitted. The type 2 businesses should already be subject to permitting. Commissioner, the issue we were running into is we had a couple citizens that reached out to the city trying to do the right thing, and when we looked at it, home baking being one of those, that under the old language, we were restricting the ability to do home baking, but the state legislature has passed laws encouraging that. So that was sort of the tipping point to where myself and Kevin Causey started looking at, okay, we want to encourage home entrepreneurship. Everybody seems to have some side hustle that they're working on these days. We want to be cognizant of that, but we want to do in such a way to where it is if it's a no to low impact type of business, to where you may just be a middleman, taking orders and placing orders, to where you never have anybody visit your home. You're just just connecting people. That's fine. We don't want to encourage, we don't want to impede that. But if it starts to quack and swim and waddle like a duck to where it's looking more, when somebody says, hey, does this look like a business? Yeah, that looks a lot like a business. Then that's why we have the type 2 aspects of it.
What comes to mind is a lot of people have in their homes, they do hair.
Sure.
So are they covered under this?
The state licensure for hair being separate and apart for this, but if they are having people physically come to their home and they're operating out of their home, then again, facts are determinative, but to me, that would be a type 2 home occupation. You could have at least one employee, as far as the advertising restrictions outside, but I think that would be a boilerplate example of what would be considered a type 2 home occupation.
So they would have to get another license?
No, not another license. It would
Same
replace
one.
whatever business license they currently have, if they have a current business license.
Right.
And as I said, we may have some businesses that have been, wanting to follow the letter of law, so they've been getting that business license, that they may truly slot into a type 1 home occupation because they never have anybody come to their house. They're not, manufacturing, making any goods on site. They may just, be doing all their work behind a keyboard. In that situation, that is a low impact type of home
Right.
occupation. We're not going to require a permit for that. So hopefully the intent was to keep at the worst the status quo, but I think in practicality, we're likely to see businesses that have been getting home occupation permits that may actually fall into a type 1 category, and if that's the case, they're able to operate without having to get that
Yeah.
piece of paper from the city.
Okay, thank you.
Yes, sir.
Mayor, that's all I have.
All right, thank you. Other discussion?
I had a couple questions.
Sure.
I just want to make sure that I understand when I read this, that I'm understanding correctly. But when when it talks about parking, we all know I
Yes, ma'am.
worry about parking.
Yes, ma'am.
I think it calls it off-street parking.
Mm-hmm.
So does off-street parking means park in your driveway? Or
It-
what does that mean?
Well, the determination as to what proper parking, that's going to be a conversation with buildings. So, I believe the intention behind that, when the discussions at least were had within City Hall, with our people that be enforcing that, would be, obviously, you need to look at the nature of the property itself. But I believe the intention is that not driveway parking, that there's going to have to be some parcel behind the building out of sight that would be suitable for parking. Again, depending upon the facts of it, the driveway may be suitable for that, but I believe the explanation as it's been given to me has been that, they're going to have to arrange to have parking the same as any other business that would have parking in that situation. So it would have to be a parking, a carport, something behind the house out of view to where that would be suitable. But again, the facts would be determined based upon where the location is.
And I think what they do, Commissioner Cole, they reference the motor vehicle parking standards for requirements. So if you're taking 25% of a building being used for a home occupation, they can back into how many spots they think are needed for that space. It could be 3, it could be 5, it could be 2. It just depends on the business.
Yeah, because just my concern is what it always is. I don't want those 5 cars blocking someone that literally can't get home or can't park in their own driveway, which is so frustrating for residents.
And I totally get that understanding, and we've tried to craft the ordinance to be reflective of that very concern, Commissioner.
Chris, also, and you have to forgive me,
You're fine.
but the ordinance currently that we're operating under, does it specify, and I apologize for not having done the homework, specify the types 1 and 2? That's for this new ordinance?
Yes, this is, as you can, some of the good word you were referring to as the strike-throughs, that was all the language in our ordinance book having to do with home occupations. And you can
Yes.
see it's a little, it's sparse.
Yes.
And in working with Kevin Causey on this, our concern was encouraging entrepreneurship in the city, but doing so from a smart growth perspective, to where, again, our concern, if you're able to do the sum total of your job in a darkened office in front of a keyboard to where you're just connecting people as a remote
Right.
type worker or whatever, then that was not something we were concerned about. But if it is forward facing and you are having the possibility of clientele or somebody coming to your home as an office, then that's when we thought the licensure as a type 2 business would be needed.
So in essence, every business then, home business, would come under scrutiny by this ordinance. Some will remain not having a required permit. Some, though, by nature of their business, then would be required to have a permit.
You've said that much better than I could. Yes, sir.
Oh, thank
Wow.
Gee, wait a minute, Jim, where'd the poppies folk go? Oh, yeah,
Here's
okay, I'm asking because, and I think maybe you've had some inquiries, but
Yes.
because we also have, and
I will be, I know the inquiry you're speaking of.
Yes.
I was waiting to get a little bit more information from McKinsey in our licensure department to see where that inquiry, what their current status is. But I can
Yes.
tell you, and I get it, that, people, well, they're wanting more money from us. No, it's making sure you're categorized or slotted where you need to be. And again, at the end of, whenever it comes up for renewal, it should be a renewal of whatever license you're currently operating under. Or it could be a situation where you've had a license up to this point. You may not need one going forward if you're in that category 1, that type 1.
yes,
Because one of the concerns that we saw was we were catching people trying to do the right thing. They would reach out to the city and say, hey, I'm operating this business, am I okay? Well, if you ask us, we got to look. And there were 1 or 2 of those properties, I mentioned the baking issue, that when we looked into it, initially our thought was, well, there could be a problem with it, but as with anything else, you do the research, you do the work, and you realize, okay, well, there's a way of doing this.
Right.
So the intention in drafting this is not that we are having people pay more money. I think ideally it's that those people that are operating those type 1 businesses are going to find out they are not, on the hook for getting any sort of licensure in order to be able to do that. But post-COVID and with the rise of home occupations, we need to have some sort of mechanism in place to where we can see who these people are and where they are. Just so we can, not that we're looking to regulate it, just so we're aware of it when it comes up.
I think it
Just a
gives
couple
some,
more. Oh, go ahead. I'm sorry.
I was going to say, I think it gives some leniency to, you have a lot of people working from home, they're in customer service or work for Amazon or tech support, that's another big one. So it gives some leniency towards home occupations like that. It helps us actually protect neighborhoods for the type 2 permit. So if they qualify underneath that type 2 permit, we're aware that they're operating in that manner and can actually watch for where they're parking, Commissioner Cole, and other things as well.
So if they, in the example you gave, if they're working for XYZ Corporation and they drive to Lexington 3 days a week and they get to work at home 2 days a week, do they physically have to come to City Hall and file a type 1 permit, or can they just keep doing what they're doing?
They would just be able to keep doing what they're doing. Now, if they want to call and get, the example you gave is exactly describing what my wife does for LBX. She works in the office in Lexington 3 days a week, and she works remotely too. That's a little bit different because she's working where her company tells her to. You know, you should still reach out, I guess, in those situations. But if you're purely working remotely, and again, the occupants, this is a home occupation, so it's more envisioned if you are operating a business. So if you may be a consultant or a third-party consultant, you know, so it's a little bit different than your primary employer saying you can work remotely 2 days a week. But during COVID, that was a huge issue in our larger cities because we had people that may work in Lexington but were working remotely from Mount Sterling, and Lexington didn't get a good bit of money because they were not working in Lexington on those days that they were working remotely during COVID. So, you know, this hopefully is a pretty large puzzle piece towards the overall goal of the city of just being aware of the types of businesses that are being done, especially if it is small entrepreneurship. And like I said, the key takeaway, at least from my point of view, is that we're not looking to add additional hurdles. Hopefully, we're taking some hurdles away. But at the end of the day, we think that the distinction between the type 1 and the type 2 is well considered and to the benefit of the city.
Last question, I promise.
Go ahead.
So is the swimming pool language just in here because some people have swimming pools at their house where they have a home business? We're not talking about a swimming pool where that would be the business, are we? It's at B3,
Yeah, it's,
Let me see here. I'm
Page
sorry, I got
3.
a new laptop, it's promptly not working here.
there's a big paragraph on it, but I guess it's just if you had a pool at your
Like
house.
if you're doing swim lessons or something?
No, that would be, what section is that in?
B3.
B3, home occupation.
Okay, I will say that is in the existing language. So what is, well, no, let's see.
that's really
Yeah,
just,
so if it's B3, okay. so-
Maybe it's C3 now.
When you're not
it's just like-
operating a swimming pool.
Yeah, no, and that is language that is currently in there, as
I
far
think
as,
that's giving the guidelines for having a home pool with a fence.
Yes.
And keeping it so far out of setbacks.
yeah, the language change that has been made pursuant to the addendums, again, the Cs and all that have been changed just because those numbers changed, but the substantive change that is before you all is A and B.
Right.
So it's the first 2 pages. Anything from C on, other than changing the heading letters, is the same.
Stayed the same.
So the substantive changes, so the pool would be just that. It would be no different than how it's been enforced up to this point, which candidly, I'm not sure how that has been enforced up until this point. The accessory use of a structure, so
It
yes.
has to do with life safety. It all has to
Yeah.
do with fencing, having the proper ladders.
Providing lifeguards
Yeah, not within a setback of a adjacent property. Self-latching gates, I mean, it's more of all life safety if you have a pool. I think what it's getting at here is if you're operating a home occupational business with a number 2 permit, and you have a pool, that pool has to meet these safety guidelines like it does have to anyway. So if somebody's visiting your home with kids for some reason, for the business you're operating, they can't wander out to the pool and fall in.
Right.
That
It's
makes-
got to have the fence, it can't be in the setbacks, it's got to have the self-latching gate, it's got to have the proper ladders, it's got to have the life safety pieces. That's the way I understand it.
Yeah, and that, like I said, that is, I guess, somewhat similar to what in the legal field is an attractive nuisance.
Right.
Have small kids, have a swimming pool, they're going to go wander off. So that's a safety issue of that. But that was not a consideration in the
changes.
underlying changes that we're discussing here today, Commissioner.
Any other?
So I think to answer your question, it has nothing to do with operating a home occupational business using the pool.
Yeah.
Yeah,
It's that the pool is present and safe.
yeah, it's got to have the safety pieces to it.
Makes sense.
Just one other strange question. Let's see, who would do this? Who would enforce this? Codes? Would this be a codes matter?
Generally, yes.
Yeah.
I mean, anytime you're dealing with business licensure, there's some overlap between codes and building,
Building
depending
codes.
on what the issue is.
Did anyone, not that you should have, run just a quick test to see how many business licenses that currently are here would come, for example, under scrutiny in the next 30 days, 6 months, year? How many licenses would be expiring? They're annual licenses, right? All
Yeah.
these permits?
Yes.
So just what might be
Mayor,
our
we.
test cases?
Yeah, we haven't crunched the numbers on that again. Again, my thought on this is that it's a business that's currently licensed, this is only going to change their type of license. Or even if they need a license, if they're a type
Actually
1.
Give them a type.
And so at the time of the next renewal, that's going to be probably a 30-second conversation that takes place, is to look at the nature of the business, and if they can tick the boxes off, we'll determine which one of these type 1 or type 2 we need to issue. But the reason that we wanted to look at this language is that we are several times a week, if not several times a day, McKinsey and Codes or somebody in Codes is being contacted by people in the community asking us questions about how they can be licensed as a home occupation. And we realized that we had a couple blind spots in treating home occupation as one size fits all. So this is sort of the first bite at the apple to see if this sort of bisection is going to do enough. There may come a time where we need to, make a couple more distinctions, but I'm a legal fullback. If I see a hole, I want to hit it, and if this is the most obvious way of doing this, that's where I like to start.
All right. Y'all want to give it a try? Any further discussion? This is, again, a second reading, and we will vote. There are no more questions, comments, no further discussion. Madam Clerk, please call the roll.
Commissioner Newby,
Yes.
Commissioner Brewer,
Yes.
Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Mayor Blythe.
Yes, thank you. Let's give it a test and see where we land. Thank you.
Thank you.
Ordinance 26-18, an ordinance of the City of Richmond, Kentucky, adopting a new section in Development Chapter 157 of the Code of Ordinances pertaining to town home development. This, too, is a second reading. Mr. Attorney, please.
Thank you, Mr. Mayor. I'll also be exercising my right to summarize this granted me by the statute.
Thank you, sir.
The proposed ordinance establishes updated development requirements for townhome projects to ensure consistent design, adequate site planning, and compatibility with surrounding zoning districts. The standards apply to all new townhome developments and set a minimum development size of 1 acre with a maximum density of 7.64 units per acre. Lot and building dimensions are clearly defined, including minimum interior lot widths of 36 feet, exterior lot widths of 50 feet, and corresponding minimum lot sizes. Individual townhome units must be between 36 and 44 feet wide, and each development must include between 3 and 8 attached units. To support functional and attractive site design, each dwelling must face a public street or primary internal drive, include livable space on the ground level, and provide attached garages. Parking must comply with the city's motor vehicle parking standards. Accessory structures are generally prohibited, though accessory parking structures may be approved administratively. We have been approached by a lot of developers that are looking at accessory parking structures, so we wanted to include that. The ordinance also distinguishes requirement by zoning district. In R2 zones, townhomes may back out onto public streets. In R3 zones, developments must allow vehicles to enter streets forward-facing and provide rear parking with safe functional circulation. PUD district parking arrangements will be reviewed on a case-by-case basis. Overall, these standards aim to create well-designed, consistent townhome developments that support neighborhood quality, traffic safety, and orderly growth.
Thank you, sir. That's ordinance 26-18 in summary. This is second reading. May we have a motion, please, to bring to the floor for discussion and approval?
I move.
Commissioner Newby,
Second.
Commissioner Brewer. Is there any discussion?
I had a question.
Yes, ma'am.
Is this all brand new because there's not any strike-through anything? So is this something that just never existed before?
Yes, ma'am.
And if so, why do we need it? Like, what problem are we solving?
That's a good question. I never want to create a solution in search of a problem. You're right, and I will admit that I was a little bit shocked myself when I was looking through the ordinances that townhome was defined in several different areas, but it was not really spelled out to this extent. The reason that, again, myself and Kevin Causey, along with our city manager, had discussed this is that there had been some prior developments as to townhomes in the community to where it was a little bit of a situation where it was a square peg and a round hole, and the developers in the city kind of tried to whittle down those square pegs to where they could fit somewhat a round hole, and it kind of maybe looks like a condominium. Well, townhomes are not condominiums. And in order to address that, what Mr. Causey did with my input and talking to our city manager about this is look at what a typical, quote-unquote, typical townhome development would look like in keeping with what our normal setbacks and property requirements would be for single-family housing, condominiums, multifamily, and somewhat looking at what that average, three to however many townhome units we normally see, to see what that average space would look like, and then essentially just, splitting it not down the middle, but down 3 or 5 different ways. Because with townhomes, the property line goes right through the wall, the shared walls. So that created a bit of a difference. So essentially what we tried to do was, if you have a 3 townhome development building, and you've got more room on the right and the left and behind and in front, is there a way that we can look at those interior units, which we've done, to maybe not have as much of a requirement for those interior units that would still be able to use the space out back, depending on that, and the sides, to where the area as a whole would be reflective of what good land use has been for condominiums and other types, but just having it fit to where it's more of a townhome model, I
And
guess.
you see that a lot more in development. You'll see a townhome development that'll have a threeplex, we'll call it. And you might have 2 units in that threeplex that are 3-bedroom with 2 car garages, and you might have 1 in that threeplex that is a 2-bedroom with 1 garage. So there's some variance between, and that goes back to trying to use the space you have to put those townhomes into that space.
Thank you, sir.
I thought we dealt with that with off-street parking and had to provide when you had those triplexes or.
We ran into some issues in some previous developments where they added a 3rd room that didn't have a closet or a door on it and was characterized as a study or bonus room. And what happened with that, we found out the hard way, was that turned into a bedroom, which added additional parking on the street because the driveways were built according to the bedrooms and not the actual bonus room. So we know exactly what we're talking about and what we've run into the past, and I think this helps with that.
And to clarify that, Commissioner, we do have language in there that parking must comply with the city's motor vehicle parking standards, which is in the development ordinance. So that's going to be controlling, no matter what.
Yeah.
So.
All right. Further question? Comment? Orders 26-18. There being none, Madam Clerk, please.
Commissioner Brewer,
Yes.
Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Commissioner Newby,
Yes.
Mayor Blythe.
Yes, thank you.
Good job.
Ordinance 26-19, an ordinance of the City of Richmond, Kentucky, changing the zoning classification for property located at Amberley Way within city limits. This is a first reading. Madam Clerk, please.
Whereas Richmond Place LLC owners have filed with the Richmond Planning and Zoning Commission an application for a zoning map amendment at Amberley Way with 21.863 acres in Richmond, Kentucky. And whereas the property is currently with a zone classification of B1, neighborhood business, and P1, professional offices with vacant land, and requesting the change be to a B3, highway business. And whereas the Planning and Zoning Commission conducted a public hearing on the requested zone change on April 15th, during which it received evidence and testimony from people in favor or opposed to the requested zone change. And whereas at the conclusion of the public hearing, the Planning and Zoning Commission resulted in a tie vote with no recommendation. And whereas the Planning and Zoning Commission at its following meeting brought the tied vote to a zone change back up for reconsideration by the entire body. At the conclusion of that meeting, on May 14th, the Commission granted the zone change, adopted written findings of facts as to the zone change, and the issue is now before the Board of Commissioners for final determination. And whereas the Board of Commissioners believe it to be in the public interest that it adopts the recommendation of the Planning and Zoning in accordance with the findings of facts adopted by that body. Now therefore be it ordained that Section 1, the Board of Commissioners does hereby adopt the recommendation of the Richmond Planning and Zoning Commission as to the requested zone change. The property in question, located in Richmond, Madison County, Kentucky, as to which the zone change shall apply for, is Amberley Way, Richmond Place, Phase 2, 21.863 acres, Deed Book 493, page 299. The Board of Commissioners does hereby adopt the findings of facts adopted by the Planning and Zoning as its findings of facts. In accordance with those findings, the zoning for the said property shall be and hereby is changed from B1 neighborhood business and P1 professional offices and requesting to be rezoned as a B3 highway business. The Director of Planning and Zoning shall make the appropriate changes to the official map for the City of Richmond, Kentucky. This ordinance shall become effective immediately upon its enactment following second reading and publication in accordance with the requirements of applicable Kentucky law.
Thank you, Madam Clerk. This is the first reading of ordinance 26-19. May we have a motion, please, to bring to the floor for discussion?
I move.
Commissioner Newby,
Second.
Commissioner Brewer.
Mr. Mayor, if I may be
Yes,
heard for a
please.
moment, because as Commissioner Cole was asking me earlier, from a procedural standpoint, I believe the legal term, this got a little screwy. And I thought I'd seen everything under the sun from being a municipal lawyer. This was a new one to me. So when this initially was brought before the Planning Commission, Commissioner Francis was not in attendance.
Yes.
So we had 3-3 was the vote. And one of the wrinkles for both of the motions on this was the motion as made by the board was a motion to deny. So it was not a motion to approve. So I will tell you the same thing I've told them twice, was that, okay, this is a motion to deny. Therefore, if your intention is to vote in favor of this zone change, you'll need to vote no on this. So that was the initial 3-3 break in the vote. As I was getting, because procedurally, if there's a tie vote, it goes forward with no recommendation one way or the other to you all as a legislative body. But in getting my ducks in a row in order to get that paperwork ready for you all, I discovered under KRS 100.211 subsection G that there's an affirmative duty on the Planning Commission to reconsider any tie vote of their own. It's not a motion made by any property owners or the developers, just within the framework, they have to reconsider this.
Proceed.
So, yeah, so I arranged to notify representation for the developers, as well as we re-notified all the property owners that this was going to be brought back. So we, even though the statute wasn't clear, we did notify everyone. Between the first and second meeting, Commissioner Francis had an opportunity to review the full video of that initial hearing, which there's a long line of Kentucky cases that say if you have reviewed the previous video or previous minutes, previous testimony, you're free to, vote one way or the other at that.
As
at
though
that
you
second
were
meeting.
there.
Yes, absolutely. And he even, to prove it, he even, shared some things with me that he saw on the video and all that. So I'm good with Commissioner Francis having done that. So when the meeting was held again, there was no additional testimony taken. There was some conversation as to, possible options in development, but obviously representation for the developers could not promise anything on their behalf, so it was just limited to the four corners of what had been presented. We had 7 members at that meeting, and there were 4 no's, which were yes, and 3 yes, which were no's. So it is before you all as if it was approved by the board.
Thank you, sir. Commissioner Newby?
Well, does anybody in here want to give their spiel before I give mine? Are you sure?
Is there any discussion?
Oh, it's my discussion.
No, yeah, I mean,
So
yeah.
you may want to sit tight.
We're asking, yeah,
Well, first of
there is
all-
no other to come but us.
First of all, everybody knows where I stand on that area. For 12 years, I've voted no for every additional house, apartment, or duplex that's proposed in that area. And now, this area, folks, is so congested and crowded. I'm just about ready to say no on everything coming out there. I think as leaders or in the community, we all get so wrapped up in, hey, we're the first or second fastest growing city in the state. Well, we get so wrapped up in that, we forget to take care of what's already there. And I think it starts with all of us, every level of the board. And I think some of the members of all boards need to develop a little testicular fortitude and vote no once in a while. And it's the area. I owned a home on Goggins Lane for 11 years. I sold it and moved 5 years ago because it was way too crowded then. And folks can't live out there anymore. I mean, I wouldn't advise anybody moving out there. And I'm sure you're going to get people coming up, developers, attorneys, saying, well, this. Guarantee you, none of them live out there. They don't got to see this. I know part of our job is bringing stuff to Richmond, but folks, we have to take care of our people first. That's my spiel.
Thank you, sir. Further discussion?
Can I, may I?
Please.
Thank you. What happens if we decide we don't want to make any changes in this and it remains professional and B1, right?
It just stays in that zoning classification.
Then,
If you voted no against this, it would stay in the current
What it
zoning
is.
classification it is in, which is B1, P1.
And part of that would be the board would need to have your own independent findings of adjudicated fact grounded in the
you're talking
evidentiary
about the
record.
planning and zoning board, or are you
I'm
talking
talking about
us?
the Board of
Board
Commissioners,
of Commissioners.
that if you reject the approval, it would need to be based upon a record and adjudicative facts grounded in that evidentiary record. So the option would be to review the hearing as conducted before the commission. And if you all want to do that, that's fine. There are allowances for you all to conduct your own hearing, if that's something you all are wishing to have, to where you could, again, act as another court for that. It's rare that happens, but it is authority that the city would have. So we would have to notice, the landowners that we were going to go that route and have all that and have another creation of the record when that took place. So,
Maybe, if you don't mind, I'm sorry.
no, you're fine.
Why are we at this point where we have to make a decision based on this from anybody? Tell me why I have to,
Well, it's the process. I mean, this was, it was Planning and zoning voted for the rezone, and it's come to you all for final decision, so that's part of the process.
It's not just part of the process, it's statutorily required under 100.211, that from the time that the planning commission reconsidered that, that started a 90-day clock for you all to act.
Well, I
So-
think it ought to go back to the planning and zoning board for their discussion.
well, it's-
Because
it's-
I'm
Let me
not
ask
for
here.
this, I
Yeah,
just don't believe
And
it.
if we, in that 90-day clock, now, if we do
Yeah.
nothing, what happens after 90 days?
If you fail to act, it will go into effect without commission.
As recommended?
Yeah, it's,
By the board, by the planning and zoning board, not us.
it would, well, yes, the city would have taken no action one way or the other, and therefore the planning commission's decision.
But we need to meet and take action to stop it if we choose so.
Yeah, I wouldn't
That-
recommend not taking action. I
Yeah.
don't think that's
That
the
if,
way to handle this.
if the intention of the board is that you have questions and you're seeking to hear from the people that would have those answers, then you're operating under a 90-day clock. We could notice a hearing within that time frame in order to hear evidence on that, and then have a second reading of the ordinance as presented to see
When
what.
did the clock start?
This was voted on
Whatever the date was voted
It
on
was
planning and
May
zoning.
14.
May 14th, so,
Okay, okay.
so 12 days
Got
ago.
some time.
Yeah, so we've got 78 days left.
Okay.
So if that is, if the course that the commission is wishing to take is that you're wanting to hear evidence and testimony on this, we can notice a hearing and hear evidence the same way we did before the planning commission.
Is it possible to interpret the findings of fact differently?
Yes, I mean, that's the whole, you could,
I mean,
it would be
like,
possible, yes, that, if you wanted to look at the record as created in the planning commission and say that, for these reasons, we're going to disagree with that, you can do so. Now, being reliant upon the record as created below, there's some pros and cons by doing that. Some things may not be as clear. If you all know that there are specific concerns you have with this, then one way to make sure that would be to make sure that your hearing is concerned. But as far as the parameters by which you all can operate in looking at whether or not the zoning is appropriate, it's that the map amendment is in agreement with the adopted comprehensive plan, or in the absence of such finding, that the existing zone classification given to the property is inappropriate, and that the proposed classification is appropriate, and that there have been major changes of an economic, physical, or social nature. That's if you want to approve it. If you don't want to approve it, you'd have to find that, it goes against the comprehensive plan. There are issues related to this as far as development, whatever, but that the proper venue for having those concerns addressed would be in a hearing, if that's the right.
But if we do nothing, it happens.
If you
Well, then
do
we
nothing.
don't, we don't need to be
We're-
ducking
let's-
anything.
Yeah, we're not gonna do that.
So then we'll do what it takes.
Okay, I mean, that's, if
mean, I don't
that
know,
is the
that's-
will, we can, I can reach out to the developers. We will notify
I guess do some
by the
research.
by the same notification that we did for the Planning and Zoning Commission, or if there's a different, whatever legally is required, and then some. We will make sure that sufficient notice is given to the property owners if you all wish to have a hearing on
Would
it.
it be a special called meeting, or could you go to their meeting in June?
It wouldn't, it has nothing to do with the Planning and Zoning Commission. This would
Not
be
a
a
special
hearing,
called.
this would be a specially called meeting by the Board of Commissioners to hear evidence on the proposed zoning change
Got it.
and all that would entail.
It really, you all need to have your own findings of fact to vote against what the planning and zoning has pushed up to you with approval. So that's what the hearing would be, for you all to collect your own findings of fact and make that determination with those findings of fact to vote against it, if that's the way the board was going to vote against it.
I'm always a little more uneasy when, and as for the record, that when that vote, for example, was a tie.
Yes.
Secondly, though, one vote one way or the other, but I'm always uneasy about that. So that's one of the considerations that I'm making at this time.
Okay.
Is it the consensus for us to have a special called hearing meeting then for this issue?
Yeah, we need a motion, we would need a motion to instruct the city to contact the residents and the property owners to have a special hearing. So,
And how will that impact, Mr. Attorney, how will that impact the fact that we have first reading tonight?
well, the first reading taking place, I mean, obviously, we are taking action in consideration of that, such by having the hearing on that. So, once the hearing is conducted, the second reading could possibly still be fine to go forward. If it goes forward, and the other wrinkle with this is that in order for you all to deny it, it has to be a majority vote of the body. So it's going to take 3 of the 5. And if there's, it's okay here, but that sometimes is an issue in council cities to where they have a quorum, but not 4 of the 6.
Okay, so if we have a second reading and we vote 3-2 no, it's still happening?
No, if you vote no, it's
Okay.
done. But I was just saying, if you all vote no, there's going to have to be findings and facts and conclusions of law
After the second reading.
from you all. After the hearing. And if the second reading and the consensus is we're okay to pass it, well, then it would just go ahead and get passed, and we would, do whatever we need to with that.
So the second reading wouldn't come until after the hearing.
After hearing.
And you have your findings of fact, and that has to be within the 90 days.
Yes.
All right, thank you. Further discussion?
I just wanted to clarify a couple things and make sure that I'm understanding right.
Sure.
This was zoned, I think I read, close to 20 years ago, give or take.
Yes, ma'am.
Several years ago. And it was zoned as P1/B1. And so it's my understanding that P1 is more of a professional office.
Yes, ma'am.
For example, perhaps a mental health, a medical, something professional
Yes.
office is what I understand that to be.
Yes.
And then B1 is more of your small kind of neighborhood businesses. But when we jump to, so we're trying to jump to B3, which is highway business.
Yes.
And I've had people ask me, and I want to make sure I'm answering this right, in terms of what a B3 business is. So what people have told me, and I just want to see if this is right, wrong, or otherwise, but for example, that could include a hotel.
Yes, ma'am.
That could include $2 generals, those type things. So can you just give us in a nutshell what we would be moving to with a B3, so we're all on the same?
Well, and that was, and again, I do not want to speak, too much for Mr. Worley, who's representing the developers, but the issue that, and I understand the concerns by the residents, is because you're looking at the B3, and that is a large pot that has a lot of different types of business. So yes, it could be hotel, motel,
long
it could be
list.
car dealers, it could be, there's a lot that could fit that, but, there's nothing, at least, again, according to the developers, there's nothing in the offing or even suspected as far as, oh, we suspect something is coming in. Because I think some of the history, and again, I don't think I'm speaking out of turn because this was mentioned at the hearing below, was that due to the terrain in this area, that it's challenging from a development standpoint. There's some green space issues and some development use with it. That's why 20 years into it, it hasn't been developed. So they're looking at options as developers as they should, and obviously the residents have their well-considered concerns about this as well.
And I will say, it's a complicated issue. I mean, I would describe it as a complicated issue. And it's hard, given the information that we have in writing in front of us, and then switching your brain so that no means yes and yes means no. That may just be a challenge for me, nobody else. But it's hard to get the whole picture in terms of the packet and what we have in front of us. And I feel like maybe that's part of our frustration. I've read it 5 times. Like, I've read it and I've reread it. And every single time, I feel like maybe I don't have, it's hard to get all the information.
Yeah.
To make sure that we're voting the way that we want to vote, and that with accurate information, just to make sure that we have the total picture, I felt like was a little bit hard on this one for me, and that may have just been me. I'm just speaking for me. But it was not an easy read.
And I understand that, Commissioner, and, some of that is that the findings and facts and conclusions of the law are presented, by the side that wins. And in that case, it's from legal representation for the developer. But, your all's procedural requirements are that you are to consider the record as created below. And, part of that, unfortunately, when I first was practicing law, we had a written transcript. Anymore, a lot of those transcripts are video, which would require you all to sit through, I think that was over an hour hearing, in order to familiarize yourself with that. If the concern is you have questions that you feel have been unanswered or you're just not sure about, then I do think a hearing would be a suitable way to address those concerns, if that's the will of the body as it sounds like it may be at this point. Because if you're unable to make a decision one way or the other based upon the record as it is currently before you, well, then you all have the ability to create a record by having a hearing.
I just, a developer or anybody, if we make a zone change, they can do whatever they want to according to what can go in that zone.
If you go to
They
B3,
can say
absolutely.
whatever, so, don't piss down my back and tell me it's raining.
That was not my intention.
I'm not
just
talking-
telling you what.
We're not talking
Yeah.
about you, but we're
Yeah.
talking about the thing between B1 and then B3. That's an entirely different animal.
And I think that's a valid, that's human nature.
Yeah.
Is that, I think psychologically you can say, oh, yeah, we fully expect X to go in here. But if you're saying, oh, there's A through triple Z of types of business that can go in there, people are going to assume, whatever the top 5 is the ones they don't want to go in there, are the ones that are going to go in there.
Let me be clear about this.
Sure.
If we change that to B3, they can put whatever they want to that fits into B3.
Yeah, B3 or any other use that would be
Yeah.
recognized for that. Yes, sir. That is correct.
Yeah, one second, President. Two things. One, and the recommendation is, the text of the ordinance, the recommendation is to grant the zone change. Now,
That-
the reason I'm saying this is because we know about the negative.
Yes.
And so that's that first thing. And the other thing is, and Commissioner Cole, you reminded me, the P1, have you seen the site, Mr. Attorney?
Yes.
P1, if I'm not mistaken, is of the nature of across the street. Is that right? With those professional
I
buildings?
believe that is
I
correct.
think, who is it?
Yeah.
The court system, the
And that was a.
probation parole, I think,
Yep.
has an office out there. There's a hearing.
And that was one of the points made at the hearing, was just that the P1 is suitable, appears to be suitable for one side, but not the other. So that was brought up and it was considered by the planning
Okay, thanks.
commission.
Somebody. Oh, can I allow him to speak at this time? or not?
I mean, I don't know if there are any other residents from this area. I mean, I think that when it's open comment, possibly that might be the time, but I would hate to have this appear to be that we're hearing
Hearing?
testimony.
Yeah.
Yes.
Typically, it's been your custom on first reading, if there were questions of me, and there have not been any, but I
Okay.
wanted to clarify if I could, just something that was said and then offer up on behalf of my client as you move forward.
Who is your client? Do you have a client?
You don't respond to that just a moment. Mr. Attorney,
If there are specific questions from the commission
from the
to
commission.
the legal representation, I think that is fine.
You're walking just a little bit better.
A little bit. I still don't know if I can beat Commissioner Brewer in a foot race yet.
I've got a hurricane.
That is a nice one. I would just put to you that my clients are happy to do whatever this body sees fit. And if you want to have another hearing, we certainly would participate in that. Obviously, we come to you with a recommendation of approval after going through the process. And there are a lot of things that could go into B3, and it is in fact rained all day, Commissioner Newman. So not just down your back, as you say. But I just wanted to be clear, though, that the planning commission always has control of this at the development plan stage. And my clients have made offers that cannot be made formally until the development plan stage of significant green space buffer on this property.
And those matters, excuse me, let me interrupt you. And I attended the planning and zoning meeting. I just happened to sit in at which that kind of thing was discussed. I believe it was the chair or perhaps the attorney said, however, in that situation, it was inappropriate to discuss even those things because there's nothing before us regarding what specifically is to go there. What can go, as your question was earlier, the B3, what can go in there, of course, that's what we've been talking about. But what your client chooses to put there is not a discussion for now. Is that right,
Correct. And I
Mr.
think
Attorney?
Mr. Johnson put it very well.
Yeah.
I made certain representations on behalf of my client, but there was not a legal mechanism at that time for me to make commitments.
Yes.
And so I just want, as the discussion is heard, whether you choose to have another hearing, whether you wait till second reading and you have questions of me or my client, that there has been a robust discussion about many of those things that I'm more than happy to have with you all in whatever setting. But there are certain aspects of it that you'd be talking about a zone change, not the development plan, but that development plan does have to go back to your planning commission. And so I just, as we talk through procedurally, Chris, everything, I want to make sure that how my client would have to proceed, both with you all and with the planning commission, if everybody understands what that would look like and what has been offered and could be offered moving forward.
So basically what you're saying is even if we approved it, it would still, whatever the project would be down the road, would have to still go before planning and zoning and get approval from that point.
Then that comes up,
Then it
yes.
comes back to us.
That's correct. Now, to be candid, specific uses, if they are allowable in a B3 zone, they would be allowable.
Got it.
That's fair,
Okay.
fair statement.
Yep.
However, where they go on that development, where the roads go, where the green space goes,
Would all be up to.
how they face the street,
Goes to them.
that all is controlled by the development plan process and your development ordinance.
But now that use wouldn't come back to you all to
Exactly.
approve, just planning and
That would
zoning.
only be planning and zoning.
Yeah, that's correct.
But
I got you.
just want to make sure when people say it could be anything in B3. Yes, it could. But how that would be situated, how it would be respected to the neighborhood and the area, that does go back to the plan.
My question is how it's perspective of the area and green space and everything. What's that got to do with the additional traffic?
And that's, that's
a whole nother
absolutely
issue.
just a fair statement. I got to
Yep.
give you that. Until the state takes hold of Lawrence Mill Road and fixes, and there's.
And out there right now, we don't. There is no fix. We're gonna harness it, maybe Band-Aid it, but there's no fix of what we've created out there. There's not. There's no fix. We can doctor it up and make it a little more easily accessible to everybody, but it's beyond fixable, folks.
And Commissioner Newby, I wouldn't fight you on that. I mean, I've stood before this body and the planning commission with every traffic study in the world, which says that it's safe, and it's safe. It's inconvenient, and it's bogged down, and that's the 100.
And let me, okay, yes, and let me bring that conversation to a close now.
Sure.
Because we're getting into,
Absolutely.
you understand, Mr. Attorney, thank you, though. All righty, that's going,
Thank you.
thank you. Any further discussion? This is first reading.
Can any residents speak?
Tell me at the end.
No, that's why no, that was allowed in the hearing that was conducted by Planning and Zoning. However, as Commissioner Brewer has just said, there is a public comments period. Did you get a copy of the agenda? There are copies, all right. There is a public comments period at which time you may comment.
Can I make some comments about planning and zoning?
I would think not. Yeah, not,
Some things that aren't brought up, that you will get caught in when it comes back.
all right. We may want to talk offline about it and then know how to proceed. The Vice Chair of the Planning and Zoning. Thank you, Dr. Miller. All right. Let's move on. Ceremonial Order 26-78, order of the City of Richmond accepting retirement by an employee in the fire department. Madam Clerk, please.
Whereas Mark Moody in the fire department has submitted his intent of retirement to the city, now therefore be it ordered by the City of Richmond accepts the retirement of John Mark Moody from the fire department effective May 31st. The Board of Commissioners would like to thank him for his service and dedication since 2006. This order shall become effective immediately upon adoption by the Richmond City Board of Commissioners.
Thank you, Madam Clerk. That's Order 26-78, ceremonial order. May we have a motion, please, bring to the floor for discussion and approval?
So moved.
Commissioner Goble
Second.
and Commissioner Cole. Is there any discussion? There being none, Madam Clerk, please.
Commissioner Goble,
Yes.
Commissioner Newby,
Yes.
Commissioner Brewer,
Yes.
Commissioner Cole,
Yes.
Mayor Blythe.
Yes, thank you. Order 26.
Mr. Mayor, I'm sorry, ma'am.
Oh, I'm sorry.
I just, not to continue beating the horse here, but I would, and if I understand correctly, I think we do need a motion and a second to instruct me as legal counsel to arrange for a hearing
For
on,
hearing?
All right, then let's take 30 seconds. Is it your desire, just discussion, is your desire that we move to a hearing or that we move directly to the second reading? What is your pleasure? Not as a motion, but what are you thinking? And then we'll
I
make a
don't
formal
want, I'm not interested in doing a public hearing.
public hearing, all right? Any
But if you-
thoughts?
But I think you need to be careful with
I know,
this
that's
because you
not-
can't,
You can't just vote.
you can't just vote no because you feel that way. There's got to be facts involved.
and I hate to cite,
Aren't you gonna present us with the facts?
That's already been
No.
done.
The
The-
findings of fact,
Well,
yeah,
then if
Mr.
you
Attorney,
got the
please.
yes,
All right.
there's a case out of Richmond, City of Richmond versus Spangler Apartments, to where if the commission must make a finding of adjudicated facts either from the record of the trial type hearing held by the planning commission or from the record of a trial type hearing held by the legislative body. So in order for you all, if the will is to disapprove of this, I think it's incumbent upon you all to get those questions in mind as far as what your concerns are
And
for
have
that
a
hearing.
public hearing?
And have the hearing, yes.
Really have to. I mean, if you're not gonna vote yes.
If you're not going to accept the recommendation from planning and zoning.
Because if it's just a straight no, we run the risk of it looking arbitrary and capricious. So we would need to have, there would need to be the commission setting out a basis as to why you disagree with the conclusions of facts and law from the planning commission.
Then shouldn't we decide about a public hearing now?
That's what.
Yes,
That's what
sir.
we're asking you to
Then,
do.
sir.
let's see if I'm in order then, Mr. Attorney. I'm going to request a motion that regarding ordinance 26-19, we would authorize the attorney to arrange for us and the city manager a public hearing,
On
as
the
is
question.
appropriate according to KRS's.
Yes.
Regarding this matter, within the time
Within
that
the
we are
90
allowed prior to being required
Yes.
to address the second reading.
And we will notify property owners and interested
May
parties.
we have that motion, please?
So moved.
Commissioner Brewer,
Second.
second Commissioner Newby. Madam Clerk, please.
Commissioner Newby,
Yes.
Commissioner Brewer,
Yes.
Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Mayor Blythe.
Yes, thank you.
Thank you, Mayor.
Yes, thank you. Okay, now that positions us then to, let's see,
Now, do we need to go back?
2678, is that what I was doing, Madam Clerk?
We're on,
26-79.
yep.
Oh, we did the
Yeah, we did.
We did the fire.
fire
We got
department.
into the
Oh,
Ready for 79.
79.
another ceremonial order, 26-79, right in front of me, an order of the Board of Commissioners of the City of Richmond, Kentucky, declaring a city canine dog to be surplus property, and authorizing the transfer of it to a trained canine police officer. Madam Clerk, please.
Whereas the city owns a trained canine dog named Logan, whose health problems make him unsuitable for further use as a police canine dog, and who has retired from the police department work and needs a forever home. And whereas the specialized training given to canine dogs may make it unsuitable as a pet for an owner who has not been trained in handling those dogs. And whereas Chief Richardson has identified a police officer with canine dog handling training and who has agreed to take the dog into his home, and the Board of Commissioners finds it to be in the public interest that the dog be declared as surplus and given to these trained police officers. Now therefore be it ordered that Logan, the canine dog, is hereby declared surplus property and suitable for donation to a canine trained police officer. And whereas the chief has hereby authorized the donation to the Richmond police officer Christopher Fraley as a K-9 police officer. And whereas Officer Fraley has indicated that he is willing to take the dog into his home as a pet and is well aware and familiar with the handling of the trained dog, and that he releases the city from any liability relating to the dog, provided that he sign and release and be prepared by the city attorney that the dog is donated to him. This order shall be in full force and effect upon reading and adoption by the Richmond City Board of Commissioners.
Thank you, Madam Clerk. Before asking for the motion, in number 2,
I saw it, yeah.
make that administrative.
Yes,
No,
uh-huh.
there's another name stuck in there. All right, may we have a motion, please, that we will bring Order 26-79 to the floor for discussion and approval.
So moved.
Second.
Second, Sister Cole and Sister Goble. We'll get there. Commissioner Cole and Commissioner Goble. Motion and second. Is there any discussion? Any discussion? There being none, Madam Clerk, please.
Commissioner Brewer,
Yes.
Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Commissioner Newby.
Yes.
Mayor Blythe.
Yes, thank you. Chief Richardson, just a quick question. Is there any plan to replace Logan at this time?
Good question, Mayor. Yes, we are in the process now of obtaining a new dog. This one will specialize in explosives. So we'll have a canine that can detect explosives and be a dual purpose also for other things. So, yeah, much needed for our city.
Yes.
But yeah, he's got a little old, and you know how German Shepherds can be with their joints. So he's still living good. He just he can't run and jump and carry on like he used to.
What kind of dog will the new canine be, Chief?
You know, I haven't actually seen the paperwork for the new one yet
Yeah.
to see exactly what, I know they have picked it out. Probably be something similar to the.
Cool.
I'm just curious, my curiosity, you just said he's like specialized in explosives.
Yeah.
So does that mean, can he still do the other stuff like, you know,
He won't.
dead bodies and stuff, or?
No,
Let me
just,
see what the
he'll
orders-
he'll specialize in explosives.
Okay.
And he'll be a patrol dog that he could work with the officer on patrol.
Great.
I was just wondering.
Yep, good question.
Thank you, Chief.
Thank you all.
Any further discussion? There being none, Madam Clerk, please. Oh, we've already done that, haven't we? Yeah, thank you. Sorry about that.
Lisa's so confused.
Order 26-80, an order of the City of Richmond hiring a parks laborer. Madam Clerk, please.
Whereas the Parks Grounds Department needs an additional full-time laborer 1, and whereas the position was advertised and interviews conducted, and whereas the interview committee has made a recommendation for hire for this position. Now therefore be it ordered by the City of Richmond Board of Commissioners that the following individuals hired contingent upon their successful completion of the city's pre-employment requirements as a laborer 1 for the Parks Grounds Department, effective payroll June 26. Pay grade 2, Malcolm Hill. This order shall be in full force and effect upon reading and adoption by the Richmond City Board of Commissioners.
Thank you, Madam Clerk. That's Order 26-80. May we have a motion, please, bring to the floor for discussion and approval?
So moved.
Commissioner Cole
Second.
and Commissioner Newby. Is there any discussion? There being none, Madam Clerk, please.
Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Commissioner Newby,
Yes.
Commissioner Brewer,
Yes.
Mayor Blythe.
Yes, thank you. Order 26-81, an order of the City of Richmond declaring property surplus and providing for the disposition. Madam Clerk, please.
Whereas pursuant to ordinance chapter 34.02, disposition of surplus and city personal property declares a list of property which shall be submitted monthly to the city manager and then submitted to the city commission for classification as to the surplus property. Now therefore be it ordered by the City of Richmond Board of Commissioners that the May 2026 property described by the list as submitted by the police department, which is attached hereto, is declared surplus and is no longer needed by the city and is not suitable for purpose of which it was intended. The attached order list is by KRS 82.083, which contains a description of the property, its intended use at the time which it was acquisitioned, and the reason of why the public interest to dispose it. And then it will be sold by electronic auction at this website, govdeals.com, following legal publication as required by the KRS 424.3130, subsection 1B. This order shall be in full force and effect upon reading and adoption by the Richmond City Board of Commissioners.
Thank you, Madam Clerk. That's Order 26-81. May we have a motion, please, and bring to the floor for discussion and approval?
So moved.
Commissioner Goble?
Second.
Commissioner Cole, is there any discussion? Everybody get a chance to look at the items?
Looks like it's a bunch of tablet computers and,
Handcuffs,
oh,
I saw the handcuffs.
holster.
holsters. There's a box of jewelry.
Yeah, we are.
It could be. Could be worth something.
Collectible toy cars.
Yeah,
Oh,
comic books.
Children's toys. Yeah. At govdeals.com.
hey, there's Star Wars and Star Trek, man.
Hint, hint, hint. All right, moving along.
Okay, sorry.
Any,
We digress.
any further discussion? Madam Clerk, please.
Commissioner Goble,
Yes.
Commissioner Newby,
Yes.
Commissioner Brewer, Commissioner Cole,
Yes.
Mayor Blythe.
Yes, thank you. Ceremonial Order 26-82, an order of the City of Richmond accepting resignation by an employee in the Public Works Department. Madam Clerk, please.
Whereas Tristan Steinmetz in the Public Works Department has submitted a resignation notice to the city, now therefore be it ordered by the City of Richmond Board of Commissioners accepts the resignation of Tristan Steinmetz from the Public Works Department as Equipment Operator 1, effective May 19th. The Board of Commissioners would like to thank him for his service since February 2026. This order shall become effective immediately upon adoption by the Richmond City Board of Commissioners.
Thank you, Madam Clerk. That's Ceremonial Order 26-82. May we have a motion, please? Bring the floor for discussion and approval.
I move.
Commissioner Newby,
Second.
Commissioner Goble, is there any discussion? There being none, Madam Clerk, please.
Commissioner Newby,
Yes.
Commissioner Brewer, Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Mayor Blythe.
Yes, thank you. Order 26-83, order of the City of Richmond hiring 2 employees in the Public Works Department.
Whereas the Public Works Department needs additional full-time labor 1 positions, and where the position was advertised and interviews conducted, and whereas the interview committee has recommended a hiring for this position. Now therefore be it ordered by the City of Richmond Board of Commissioners that 1, the following individuals are hired contingent upon their successful completion of the city's pre-employment requirements as laborer 1 for the Public Works Department effective June 1st. Pay grade 1, Felix Clems Brandon Robinson. This order shall be in full force and effect upon reading and adoption by the Richmond City Board of Commissioners.
Thank you, Madam Clerk. That's Order 26-83. May we have a motion, please, to bring to the floor for discussion and approval?
So moved.
Commissioner Cole,
Second.
Commissioner Newby, is there any discussion? There being none, Madam Clerk, please.
Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Commissioner Newby.
Yes.
Mayor Blythe.
Yes, thank you. Order 26-84, an order of the Board of Commissioners approving a change order for the wayfinding and signage bid package on the Richmond Regional Sports Complex. Madam Clerk, please.
Whereas the city is currently completing the wayfinding and signage bid package for the Richmond Regional Sports Complex, contracted with Sign Magic 2, Inc., doing business as Instant Signs, which has made a recommendation for a change order, and whereas the City Commission has reviewed the agreement and made a recommendation to move forward. Now therefore be it ordered by the City of Richmond Board of Commissioners authorizes the following change order 1 for the Richmond Regional Sports Complex with the wayfinding and sign package between the City of Richmond and Sign Magic 2, doing business as Instant Signs. Change order number 1, which is an additional kiosk signs, additional trail signs, You Are Here signs, additional disc golf rules, and a correction in pricing and the interpretive display signs for a total cost of $366.16. Funding for this project will be allocated from the Richmond Regional Sports Complex Project General Obligation Series 3 bond. This order shall become effective immediately upon reading and adoption by the Richmond City Board of Commissioners.
Thank you, Madam Clerk. That's Order 26-84. May we have a motion, please, to bring to the floor for discussion and approval?
So moved.
Commissioner Goble,
Second.
Commissioner Newby, is there any discussion?
Mayor, if I may?
Please.
As you can imagine, on 280 acres, you need a lot of signage. And this actually comes from the recommendation of our Parks and Recreation Director, Aaron Sharp, and myself. After the sign package was approved, went into fabrication, we were on site looking at places we felt like we need more directional sign, and also the "You Are Here" signs. You see those near restrooms, just to give you an idea where you are on the park. So really, this is at the request of Aaron and myself.
And I think we've started that You Are Here trend even with the Historical Society as it placed those 3 or 4 signs around town for
Yep.
history purposes.
Exciting times, though. The park is coming down the stretch here.
Yes.
It's getting close.
Please.
Any further
Hallelujah.
discussion? Any further discussion? Any further discussion? There being none, Madam Clerk, please.
Commissioner Cole,
Yes.
Commissioner Goble,
Yes.
Commissioner Newby,
Yes.
Commissioner Brewer,
Yes.
Mayor Blythe.
Yes, thank you. This is the public comments period. Is there anyone, Madam Clerk, who has signed up in the office, first of all, to be considered tonight at the public comments period?
I think Dr. Miller and Coy Perkins had requested to be.
Yes. Mhm. All right, thank you.
I'm Dr. James Miller, and I'm on planning and zoning, and Ms. Coy Perkins is also on planning and zoning. And as you've already heard, there's been a lot of contentious discussion about this change in zoning, and I think some of the comments were exactly right. You already have the thing about the districts, the business districts. When you go up, and if you pull up your map on Eberly Way, I think you have a map that told me on your computer. Maybe you don't need to. But anyway, if you go up there by Richmond Center, that's a B3. When you come down that road, that is not a B3 down there where that property is. That actually is a B1. That's why it was zoned that way. Things haven't changed really down there. And they tell us that they cannot hardly build because of the fact that it's such bad land. Well, I've been on it long enough. You can build anywhere, okay? And if you approve this, okay, it'll be 3, there's only a 50-foot buffer. That's it. And you can't change that. When they bring that plat back, they cannot change that. In fact, I've had one lawyer tell me, because I wanted to change something, because I didn't think it was right, you made it a B3. I'll do what I want. I'll do according to what the restrictions are. You cannot change that. So that's a little loophole that they've got, okay? And then on top of that, they don't have to tell you, even after you've approved it, before you approve it, by law, they don't have to tell you what they're gonna put there. So these people already know what they're gonna put there. Okay, you can put a 10-story hotel there, 50 foot away from these other homes. And that's where I come in here, is because I didn't think that was right to those people in Castlewood. They put a lot of money in those homes. They gonna have a hotel or something there that's really gonna destroy their property values. They're gonna have a lot of traffic. They can't do anything about, no matter what they talk about. It is totally an inappropriate zone for that area. And you have to get on planning and zoning for a while to know some of these loopholes. You talk about how hard it is sometimes to read through that stuff. It is, and it takes a little while to understand it. We have a lot of new members on planning and zoning. Some of them don't understand what it's gonna be. I've heard some of them come back after doing that and telling me that, well, we can change it when they come back. You can't change it, that's it. So I would suggest strongly that you guys disapprove that. That if you want to have a hearing, that's fine. I think that'd be a good way to understand some more about it, get some more comments about it. But this really wouldn't be progress. This would really be destroying another community, a whole subdivision. And that's exactly what's going to happen.
And as far as the comprehensive plan goes, in my opinion, you're going from B3, which borders the Barnes Mill, and they want it to become a B3 right next to an R1, and that should not ever occur. That should be prohibited. And that is not a smooth transition as is called for by the comprehensive plan. Now, Mr. Worley, he's very persuasive. He's a good attorney. I don't know, he's not good. But he will have us believe that, oh, these people are so magnanimous, they will give us tons of green space on that Amberley Way. And we know good and well that once it's a B3, we have no recourse whatsoever. It's whatever they say. They can put a car dealership there. They can do, you know, as he said, the hotel, they can put it whatever they want, and we can't deny it on that principle because, no, it's zoned to B3. So they're stuck, and it's totally unfair, and I'm not gonna bore you with everything I was gonna say, but, you know, the residents were told one thing when they purchased these homes, there's not gonna be any kind of, you know, it's gonna be green space, and it's gone through massive changes over the years, and if it's the same, I don't know if it's the same people, the developers that told them one thing and now are pushing for a B3, but you can't trust that. And then my other little tirade is, we so often, and we do it too, turn deaf ears to the residents of our communities. And you must know, these are the people that vote you in office. We represent these people, and, you know, we need to listen to the people as much so as we do the developers. You know, everybody wants a little development, but as you say, man, that area is packed. And they're complaining that they haven't been able to sell their property. Well, that's because there's a lot of properties still for sale, and if it all becomes infill, oh my gosh, it's gonna be a massive disaster. So, the three of us, Dr. Short and Dr. Miller and myself, were the ones that voted against the R1, the B3. And some of our members are very, I can't say anything. I don't think some members should be on the board, but that's my opinion too. But we just ask that you please disregard our planning and zoning recommendation.
I think we have.
I think in this case they're wrong. I do. I think they're wrong. And I think in some cases in the past they've been wrong, okay? I've usually stood up for the people, because I think that's what the planning and zoning committee is about. Is to follow the rules, but also to protect people in their homes. And, you know, try not to do too much traffic around and try to figure out some way that you can restrict it, if it's possible, so that people can live here with a better quality of life. That's hard to do sometimes. But I think we try. Some of us really try to do the right thing. And that's all you can really say.
Please help us. Help our community.
Okay?
Thank you. Thank you very much. Thank you. All righty. Excuse me. The allergies of the rain.
Thank you for the opportunity to speak. My name is Ed Brown, and I want to thank both you members of P&Z. The last time that I spoke in front of, we had an issue with my neighborhood in front of planning and zoning. You were both very thoughtful. You went to the crux of the matter, and in fact, I shouldn't say this, but you voted differently, but I respected both votes. I think you wanted to do the right thing.
He's wrong sometimes.
You know, I was wrong once too. I would encourage, and I appreciate what you said, I have to drive that area as well. I live in Old Town. We fought a fight and lost, and I understand that, and that's a fait accompli, which we call back in the hills a done deal. People talk about traffic on Barnes Mill. It hasn't started yet. There are over 200 units going in behind Richmond Center. There are several hundred units on Hampton Way. There are 1,100 housing units plus 67 acres of commercial on Goggins. And there's 138 acres of development at Mule Shed and Crutcher Pike. That hasn't even started yet. I'm not against development. I've rehabbed residential homes. My dad was a carpenter. I'm not against it, but it has to be smart. I would encourage you, as you consider this proposal to go from B1 to B3, to consider the traffic that would be added under the worst-case scenario, because I think if you were to do less than that, and I say this with all due respect to each of you on this commission, you'd be negligent. Because if you assume something less than it's going to be and it ends up more, it's a bigger mess than any of us really can tolerate. There's a notion also that somehow the state plan is a deus ex machina. It's going to come down from the sky and going to save us from all our problems. For those that believe that, I have a task for you. One afternoon, drive to Lexington, go down Southland Drive, stop at any of the businesses that you like to, and at about rush hour, make your way back to Nicholasville Road and head south. Now, the nice thing about doing that is, by the time you get to Man of War and you're an old retiree like me, you'll have another couple direct deposits put into your account, because you're stuck. The state has spent more money on that road probably than any road in central Kentucky. So I would encourage you, as you consider the traffic ramifications of this proposal, not to succumb to the notion that the state's going to solve all the problems, as you said. It can address, and it will do its best. They're good people at the state. They'll do the best they can, but they can't undo what's already been done and what's being proposed. I don't know what the numbers would be under the worst-case scenario. I shouldn't say worst-case scenario. Highest traffic scenario would be 3. I don't know what that would be. That's for you to decide. I don't know what B1, P1 would be. But somehow in there, there's going to be a difference. And I ask you to consider that before you approve this. There's an old saying from back in the hills where my family's from. You can't put 10 pounds of fertilizer in a 5-pound bag. But we're at about 8.5 pounds right now in Barnes Mill. I appreciate your consideration. Thank you very much.
Thank you, Ms. Brown. Anyone else? Yes, please come. State your name for the clerk, please, for the record.
My name is Janice Barton, and I live in the Castlewood subdivision. So I just have a few comments. First of all, I am not going to talk about traffic. I know you all have heard all you want to hear about the traffic. My concern is the disruption to our neighborhood. We're a small subdivision back in there, about fewer than 80 homes, one street in, one street out. And to jump from B1, P1 to B3 is a big jump, in my opinion. Right now, the closest businesses to us are B1, and that is the senior living subdivision and the parole hearing business that is roughly at Brighton Way and Amberley. They are both closed by 4:30 p.m. They don't produce a lot of traffic. There's no noise, and there's no light pollution. Jumping to B3, we're not sure what we could get out there. One morning I was out early and I was noticing as I drove by all the really nice hotels there, how very brightly lit they are, which is desirable and aesthetically pleasing for a hotel, but not if it's 50 feet from your backyard. So I'm a little concerned about that. The other thing is that has been mentioned is the challenging terrain of that. I think there could be unintended consequences with trying to level that out enough to make it a good site for a large business. I know you all don't answer questions, so I'm not going to ask one. I'm just going to say that I do hope that if there is a hearing, that we will be, have enough time to prepare and get more people to come. Thank you.
Thank you for your kindness. Ms. Martin. Anyone else? Yes, please.
Good evening. I'm Diana Botner. I live 1088 Amberley Way, and I just want to ask you to very seriously consider leaving the property zoned as it is. The senior center, the parole board, and the hearing clinic, all of that is okay, it's fine. And that type of business would be okay, but to build anything more than that is just, it's not going to be good for that area or that community. And as a resident of that community, and I know how all the residents feel, they would like to be listened to, and they would really appreciate you not allowing that zone to change. Thank you.
Thank you. Anyone else in the audience? Thanks to all of you. Mr. City Manager, please.
Mayor, I don't have anything for the group tonight. It was a cold weekend at the swimming pool, so I have nothing to report.
I went out yesterday and spent a little time, and the kids were all excited.
Yeah,
It was cold.
They was freezing to death. So I can tell you.
Yes, indeed. Off to an interesting start. Commissioner Goebel,
I'm good.
all righty. Commissioner Brewer, and again, glad to have you back tonight. Hope you're healing well. Commissioner Cole,
Just two really quick things, so I don't get in trouble with Commissioner Newby over here.
He's already rolled his eyes.
I just wanted to say thank you to everyone that came out tonight to participate in city government. You know, I just appreciate it when people are professional and respectful, and they love Richmond and they care about their community. So if you're one of those individuals that devoted time to coming out on a rainy night, I thank you for doing that. And second, we would be remiss if we did not say happy birthday to Commissioner Goebel on the end over there.
It is, I'm 60 today. Isn't that
yay.
Happy birthday.
I told you, Rob, she wasn't 65.
Rob,
Thanks a lot. There we go.
yeah. Y'all will be getting
I
in
said she's
trouble.
30.
You enjoyed that being brought up.
65, Thank you, guys.
well, you know what, and I'm
I'm
sorry.
blessed.
Thank you, Commissioner Cole. Today I had the greatest opportunity. I was at one of our newest restaurants, and a couple of our police officers were there. One whose 3-year-old daughter was there, and they were celebrating her birthday, and her name was Maribel. But so I went to the child, and I was talking with the officers, and I said, would you mind? I looked at her. I didn't care what they thought. I looked at her, at the child, and I said, would you mind if I sang happy birthday to you? And she was the biggest grin. She said, no. So that was a 3-year-old. So I want to finish my day well.
Oh, my goodness.
Not only with a 3-year-old, but also with a
Oh, I can't wait.
I can't.
happy birthday to you. Happy birthday to you. Happy birthday, dear Mindy. Happy birthday to you.
Thanks for that harmonizing. Good job, Kelly.
Now I feel better.
And how old are you?
Oh, way too old. Thanks, guys.
Let me say what I say very seriously to folks. It's good to have birthdays.
It is.
It's good to have birthdays.
Better than the alternative.
You're better than the alternative, exactly. Commissioner Newby? Is that all?
I think I probably said enough tonight.
All righty. I understand that, well, obviously, Tasty Tuesdays is canceled for tonight, is that right? It's raining still, and,
But the ARC building is still going.
Yeah, exactly.
the what I'm saying?
ARC building is still going on.
They're building an ark. Yeah,
Yeah, uh-huh.
that's what he's saying.
To be completed by when? Okay. Thanks to all of you who have come tonight, and who has just made that comment about participating. Yeah, we appreciate that. And folks, we really do listen, and we do hear you. So thank you so much for those things that we would not ordinarily know did they not come to us firsthand. So thank you. Chiefs, thank you. Josh, thank you. And board member Wayne, thank you. To all of you, I won't talk about, but that man is special to me because of a dog. Yeah, because of a dog. And I promise you I won't cry. Yeah. Thanks, Mr. City Manager, Mr. Attorney, Madam Clerk. Thanks to our Public Information Officer, Kelly, who's here tonight. And thank you to Carrie and your continuing encouragement of new businesses, which is really important. The members of the board, thank you so much. The Commission for Planning and Zoning. I tell folks often, other than the commission itself, is he looking at me?
There's some cat walking down the street. You want to throw him a congrats too?
You so bad.
I'm just messing with you. I
And
love
then there's
I love
Blake.
you, man.
There you
Blake,
go.
thank you for representing the register tonight.
We already took
And
a
then,
perfectly short meeting and made it like the longest.
Thanks, Pat. The hardest working man in the building never gets any recognition. Pat, we're grateful that you do all this for us. And okay,
There's the cat walking down.
all hearts and minds are clear.
Amen. Yes. Hallelujah.
We will entertain a motion.
So moved.
Yeah,
Second.
all right. Motion, Commissioner Cole. Second, Commissioner Goebel. What do we say, Madam Clerk? All in favor, get up and leave?
Yes.
That sounds great.
Yeah.
All in
Thank
favor,
you.
say aye.
Thank you all. Thank you all. Seriously, thank you. A little less.